Private international law. The branch of international law which regulates the comity of states in giving effect in one to the municipal laws of another relating private persons, or concerns the rights of persons within the territory and dominion of one state or nation, by reason of acts, private or public, done within the dominion of another, and which is based on the broad general principle that one country will respect and give effect to the laws of another so far as can be done consistently with its own interest. Foreign element, a factual situation that cuts across territorial lines and is thus affected by the diverse laws of two or more states. Comity, the recognition which one state allows within its territory to the legislative, executive, or judicial acts of another state, having due regard both to international duty and convenience and to the rights of its own citizens or of other persons who are under the protection of its laws. Lex situs, the applicable law regarding the acquisition, transfer, and devolution of the title to property is the law where the property is located. Lex fori or lex fori, the law of the forum where the case is filed. Lex loci actus, the law of the place where the act is done. Lex loci celebrationis, the law of the place where the contract is entered into. Lex loci contractus, the proper law applicable is deciding the rights and liabilities of the contracting parties. Lex loci delictus, the law of the place where the offense or wrong took place. Lex loci domicile, the law of the place of the domicile of the person. Lex loci re situ, the law of the place where a thing is situated. Gilbert Doctrine, a rule to the effect that the form is not bound by the law of the place of injury or death as to the limitation on damages for wrongful act, because such rule is procedural and hence the law of the form governs the issue. Center of gravity doctrine, most significant relationship theory, grouping of contracts. Choice of law problems in conflict or loss are resolved by the application of the law of the jurisdiction which has the most significant relationship to or contact with events and parties to litigation and the issue therein. General rule: law of one country has no application and force in another country. Philippine laws have no extraterritorial effect. Exception: consent when our laws provide extraterritorial effect to our laws with respect to citizens and nationals, example extraterritoriality principle of RPC. But now in PRIL, foreign laws and foreign judgments may be given force and effect in our country because of the growing interdependence of states and on basis of principle of comity. Two remedies involved. Number 1, enforcement of rights. Number 2, recognition and enforcement of foreign judgment. Conflict of laws presupposes two or more conflicting laws between a local and a foreign law involving a foreign element or elements, which requires a determination of which law should apply. Is there a conflict case? A factual situation that cuts across territorial line and is affected by the diverse laws of two or more states is said to contain a foreign element. The presence of a foreign element is inevitable since social and economic affairs of individuals and associations are rarely confined to the geographic limits of their birth or conception. Saudi Arabia Airlines versus CA GR number 122191. The forms in which this foreign element may appear are many. The foreign element may simply consist in the fact that one of the parties to a contract is an alien or has a foreign domicile, or that a contract between nationals of one state involves properties situated in another state. In other cases, the foreign element may assume a complex form. Saudi Arabia Airlines versus CA. In the instant case, the foreign element considered in the fact that private respondent Murada is a resident Philippine national and that petitioner Saudia is a resident foreign corporation. Also by virtue of the employment of Murada with the petitioner Saudia as a flight stewardess, events did transpire during her many occasions of travel across national borders, particularly from Manila, Philippines to Jeddah, Saudi Arabia, and vice versa, that caused a conflict situation to rise. Three ways of solving conflicts of laws problem. Court may refuse to hear the case and dismiss it on ground of lack of jurisdiction or forum nonconvenience. Number two, court might decide a case by its own local law. Number three, court might decide a case by special rules formulated to address the problem. Choice of law principle, general rule. Foreign laws and judgments have no effect in the Philippines. Exception, consent, express, there is a law or implied, committee. Characterization and points of contact. Characterization or doctrine of qualification is a process of deciding whether or not the facts relate refer to the connecting factors to the kind of question specified in a conflicts rule to enable the forum to select the proper law. Elements of characterization. Foreign element. Points of contact. Proper law applicable. Test factors. Points of contact. Connecting factors. Number 1. Nationality of a person, his domicile, his residence, his place of sojourn, or his origin. Number 2. The seat of a legal or juridical person, such as a corporation. Number 3. The situs of a thing, that is, the place where a thing is or is deemed to be situated. In particular, lex situs is decisive when real rights are involved. Number 4. The place where an act has been done, the locus actus, such as the place where a contract has been made, a marriage celebrated, a will signed, or a tort committed. The lex loci actus is particularly important in contracts and torts. The place where an act is intended to come in effect. Example, the place of performance of contractual duties, or the place where a power of attorney is to be exercised. Number 6. The intention of the contracting parties as to the law that should govern their agreement, lex loci intentionis. Number 7. The place where judicial or administrative proceedings are instituted or done. The lex fori, the law of the forum, is particularly important because, as we have seen earlier, matters of procedure not going to the substance of the claim involved are governed by it, and because the lex fori applies whenever the content of the otherwise applicable foreign law is excluded from application in a given case for the reason that it fails under one of the exceptions to the application of foreign law. Number 8. The flag of the ship, which in many cases is decisive of practically all legal relationships of the ship and of its master or owner of such. It also covers contractual relationships, particularly contracts of freightment. Conflicts problem, jurisdiction, characterization, points of contact, state of the most significant relationship. Saudi Arabia Airline versus CA. Facts. Morada, a Filipino flight stewardess for Saudia, was attempted rape by Saudi Arabian national crew members in Indonesia. She returned to Manila, and while there, she was convinced by Saudia manager to go to Jeddah and sign some papers purporting to some release forms in favor of her fellow crew members. It turned out that the documents were court summons and orders trying and finding her guilty of adultery and other violations of Islamic tradition. Upon her release and return to Manila, she filed a case for damages based on Article 19 and 21 of the Civil Code. Health. There's a conflict problem as there is a foreign element involved. Morada is employed by a resident foreign corporation, an international carrier, and some of the acts complained of occurred in Jeddah. The trial court has jurisdiction over the subject matter, damage suit based on Article 19 and 21, and over the persons of Morada, plaintiff, and Saudi by voluntary submission by filing answer. For characterization, the point of contact considered is the lex loci actus, or the place where the tortious act causing the injury occurred, which is Manila, Philippines, since this is where Saudi deceived Morada. The state of the most significant relationship rule was also applied, Supreme Court holding that the Philippines is where the overall harm of the injury to the person, reputation, social standing, and human rights of Morada had lodged. In sum, morada is entitled to recover for damages. Choice of applicable law. Two important questions in a choice of law problem. Number 1. What legal system should control a given situation where some of the significant factors occurred in two or more states, solved by characterization? Number 2. Question. To what extent should the chosen legal system regulate the situation? Philippine statutory directives on choice of law. Personal law, nationality rule, family rights and duties, those which arise from family relations, and include those between husband and wife, and between parent and child, among other ascendants and their descendants, and among brothers and sisters. Status, birth, marriage, death, legal separation, annulment of marriage, judgment declaring the nullity of marriage, legitimation, adoption, acknowledgment of natural children, naturalization, loss or recovery of citizen, civil interdiction, judicial determination of filiation, voluntary emancipation of a minor and change of name, condition, legal capacity, property, lex re side. Personal law, national rule, Renvoi Doctrine, Doctrine of Processual in Presumption, Bellis versus Bellis, GR number 23678. Facts. Amos Bellis, a U.S. citizen, died a resident of Texas, and he left two wills, one devising a certain amount of money to his first wife and three illegitimate children in another, leaving the rest of his estate to his seven legitimate children. Before partition, the illegitimate children, who are Filipinos, opposed on the ground that they are deprived of their legitimacy. Issue: whether the applicable law is Texas law or Philippine laws. Held: applying the nationality rule, the law of Texas should govern the intrinsic validity of the will, and therefore answer the question on entitlement to legitimes. But since the law of Texas was never proven, the doctrine of processual presumption was applied. Hence, Supreme Court assumed that Texas law is the same as Philippine laws, which upholds the nationality rule. Renvoi Doctrine is not applicable because there is no conflict as to the nationality and domicile of Bellis. He is both a citizen and a resident of Texas, so even if assuming the law of Texas applies the domiciliary rule, it is still Texas law that governs because his domicile is Texas. Legal capacity, law of the place where contract was entered into. Government versus Frank, GR number 2935. Facts. In Chicago, Illinois, USA, Frank entered into an employment contract as stenographer with the government. The contract is to be performed in the Philippines. However, upon arrival in the Philippines, Frank left the service. Government thus sued him for the breach. Frank raised the defense of minority, contending that by Philippine laws he does not have legal capacity to enter into contracts. Issue: whether or not Frank has legal capacity to enter into contracts. Held: it is not disputed that at the time and place of the making of the contract in question, the defendant had full capacity to make the same. No rule is better settled in law than that matters bearing upon the execution, interpretation, and validity of a contract are determined by the law of the place where the contract is made. Matters connected with its performance are regulated by the law prevailing at the place of performance. Matters respecting a remedy, such as the bringing of suit, admissibility of evidence, and statutes of limitation, depend upon the law of the place where the suit is brought. The plaintiff, defendant, being fully qualified to enter into the contract at the place and time the contract is made, he cannot plead infancy as a defense at the place where the contract is being enforced. General rule: no foreign law may or should interfere with the operation and application of Philippine laws. Exception: 1. When the Philippine legislature has, by law, given its consent to the extension of a specific foreign law to the Philippines. Example: COGSA. COGSA is Carriage of Goods by Sea Act. It's a Public Act number 521. The provision of Public Act 521 of the 7th Congress of the United States, approved on April 16, 1936, be accepted, and it is hereby accepted to be made applicable to all contracts for the carriage of goods by sea to and from Philippine ports in foreign trade, provided that nothing in this act shall be construed as repealing any existing provision of the Code of Commerce which is now in force, as a limit as or as limiting its application. Okay. When used in this act, the term carrier includes the owner of the charter who enters into a contract of carriage with the shipper. The term contract of carriage applies only to contracts of carriage covered by a bill of lading or any similar document of title, insofar as such document relates to carriage of goods by sea, including any bill of lading or any similar document as aforesaid issued under or pursuant to a character party, from the moment of which such bill of lading or similar document of title regulates the relations between a carrier and a holder of the same. Number 2 of exemptions. When Congress enacts a law adopting or copying a specific foreign statute. Number 3. When state enters into a treaty or convention. Number 4. When parties themselves stipulate that foreign law governs the relationship. Number 5. Borrowing statute. A statute which directs the court of the forum to apply the foreign statute to the pending claims based on a foreign law. Number 6. When Philippine conflict of laws rule refer to foreign laws as applicable law. Example, nationality principle. Exception to the borrowing statute. Catalin versus POEA, GR number 104776. Facts. Catalin et al. Are OCWs deployed to various Middle Eastern countries, including Bahrain. Under the contract, the choice of applicable law is Bahrain law in case of contractual dispute. The contracts were later pre-terminated, so Catalin et al. Filed with RTC a case for recovery of unpaid wages, etc. Under Bahrain law, the action is already prescribed. Issue whether or not Bahrain law should be applied on the question of prescription of action held. Statute of limitation is sui generis. It may be procedural or substantive, depending on the characterization given such a law. This distinction, however, becomes irrelevant when there is a borrowing statute, as in the case of our rules of court, which provides that any action barred under the law of the country where the cause of action arose is also barred in the Philippines. But in this case, Supreme Court did not apply our rules of court on the ground that doing so would contravene the constitutional provisions on protecting the rights of labor. The courts of the forum will not enforce on foreign claims obnoxious to the forum's public policy. Agreements and applicable law. General rule. Parties are free to stipulate as to the applicable foreign law to govern their dispute arising from the contract. Exceptions. 1. Where there is some basis for applying law of the forum minimum contract. Number 2. Where plaintiff and defendants are both residents of the forum. Number 3. Where a reasonable reading of the choice of law and forum agreement does not preclude the filing of the action in the residence of the plaintiff or the defendant. But if there is no agreement as to applicable law governing contract, apply the law of the state of the most significant relationship, taking into account the following contacts. Number 1. Place of contracting. 2. Place of negotiation of the contract. 3. Place of performance. 4. Location of the subject matter of the contract. 5. Domicile, residence, nationality, or place of incorporation and place of business of the contracting parties. Numbers. Choice of law on jurisdiction treated as choice of venue. HSBC versus Sherman, GR number 72494. Facts. A Singaporean company applied with and was granted by the Singapore branch of HSBC an overdraft facility secured by a joint and several guarantee executed by the former's director, the Filipino resident. In the guarantee, there is a clause stipulating that jurisdiction over and dispute arising from the transaction is vested with the Singaporean courts. When the Singaporean company defaulted, HSBC filed suit against the directors in the Philippines. Issue whether or not the choice of law clause should be held. held. Jurisdiction, which finds its source in sovereignty, cannot be bargained away by the parties. The state can assume jurisdiction when there is a reasonable basis of exercising it. To be reasonable, the jurisdiction must be based on some minimum contacts that will not offend traditional notions on fair play and substantial justice. In the present case, the minimum contact considered is the Philippine residence of the private respondents. In assuming jurisdiction, Supreme Court held that the parties did not stipulate that only the courts of Singapore, to the exclusion of all the rest, has jurisdiction. Because jurisdiction cannot be stipulated upon, the choice of jurisdiction was treated as a choice of venue. In applying thus, the choice of venue is only permissive in the absence of restrictive words to lend exclusivity to the chosen form. Application of foreign law. How foreign law is governed. Given application in the Philippines by statute, directives, consent of the state, by agreement of the parties, by treaty or convention, by conflict of laws rule. Principle governing conflict of law cases. Number 1. Substance versus procedural principle. All matters of procedure are governed by the law of the forum where the case is filed, while matters of substance are governed by the law of the country where the cause of action arose. Problem. Some laws may be treated by one country as procedural and by another country as substantive. Example, statute of limitations. Solutions. Government interest analysis. The law of the country whose interest is most impaired by failure to apply its statute should be applied. Borrowing statute. The law of the country has a statute borrowing the prescriptive period provided in the foreign statute. Exemption when contrary to public policy or prohibitive laws. Center of gravity doctrine. Grouping of contracts principle or state of the most significant relationship theory. Law of the state which has the most significant relationship with the occurrence and with the parties determines their rights and liabilities in tort or in contract. What is tort? Tort, wrong, injury, the opposite of rights, according to Lord Coke, because it is wrested or crooked, being contrary to that which is right and straight, according to Black Laws Dictionary. So it may be either a direct invasion of some legal right of the individual, the infraction of some public duty by which special damage accrues to the individual. Number 3, the violation of some private obligation by which like damage accrues to the individual. In the former case, no special damage is necessary to entitle the party to recover. In the two later cases, such damage is necessary. Next, Renvoi doctrine, or the table tennis theory. The conflict of law rule of the forum resorts to the foreign law, which in turn refers back to the law of the forum. Renvoi doctrine applied. Asner versus Garcia, GR number 16749. Facts. Edward Christensen, who is at his death was a U.S. citizen, but domiciled in the Philippines, left the will, devising unto Maria Helen a certain amount of money and giving the rest of his estate to Maria Lucy. Helen opposed the partition of the ground that she is deprived of her legitim. Her contention is that the law of California directs the law of the domicile should govern the will. Issue whether or not the national law or the domiciliary law should apply. Held. The intrinsic validity of wills is governed by the national law of the decedent. In the present case, the national law of Edward is the laws of California. However, there were two conflicting California laws regarding succession. One is enumerated in Re Kaufman, which does not provide for legitims, and another is Article 946 of the California Civil Code, which provides that the law of the domicile applies. Supreme Court held that the national law is Article 946, which is the conflict of laws rule of California. The reason is that in Re Kaufman applies only to residents, while Article 946 is specific to non-resident. Thus, since Article 946 contains a refer back to Philippine laws, the law of the domicile, then Maria Helen is entitled to her legitime. Number 4. Lex fori. The law of the forum governs all matters pertaining to procedural or remedial rights. Applicability of foreign laws and its exemption. When foreign law, even though applicable, may not be given application. Number 1. Foreign law contravenes prohibitive law or public policy of the forum. Number 2. Relationship of the parties affects public interests. Number 3. Real property is involved. Apply lex resite. Number 4. Foreign law, judgment, or contract is contrary to sound and established public policy of the forum. Number 6. Foreign law is procedural in nature. Lex orif governs procedural matters. Number 6. Foreign law is penal in nature. Exception, contrary to sound public policy. Bank of America versus American Realty Corporation, GR number 133876. Facts: Bank of America, duly licensed to do business in the Philippines and existing under the laws of California, USA, granted US dollar loans to certain foreign corporate borrowers. These loans were secured by 2 real estate mortgages by American Realty, a domestic corporation. When the borrowers defaulted, Bank of America sued some before English courts. While these cases were pending, Bank of America likewise judicially foreclosed the real estate mortgages in the Philippines. Thus, American Realty sued for damages against Bank of America, held whether or not Bank of America can judicially foreclose the real estate mortgages despite pendency of the civil suits before English courts, held. English law purportedly allows the filing of judicial foreclosure of mortgage despite pendency of civil suit for collection, but English law was never properly implemented and proven. Thus, the doctrine of processual presumption applies. Supreme Court further held that even assuming arguendo that English laws were proven, said foreign law would still not find applicability when the foreign law, judgment, or contract is contrary to a sound and established public policy of the forum. The said foreign law, judgment, or others shall not be applied. Additionally, prohibitive laws concerning persons, their acts or property, and those which have for their object public order, public policy, and good customs shall not be rendered ineffective by laws or judgment promulgated or by determinations or conventions agreed upon in a foreign country. The public policy sought to be protected in the instant case is the principle embedded in our jurisdiction proscribing the splitting of a single cause of action. Moreover, the foreign law should not be applied when its application would work undeniable injustice to the citizens or residents of the forum. See authentication, electronic evidence, and judicial cognizance of foreign judgment. To be recognized by Philippine courts, foreign laws and judgments must be alleged and proved. How foreign public documents are proved. Official publication. Number 2. Certified true copy, one attested by the officer having the legal custody of the record or by his deputy, and accompanied with a certificate of that such officer has custody. The certificate must be made by a secretary of the embassy or legation, consul general, consul vice consul, or consular agent, or by any officer in the foreign service of the Philippines stationed in the foreign country in which the record is kept, authenticated by his seal or office. If the foreign law or judgment does not comply with the above requirements, it will not be recognized and the doctrine of processual presumption will apply. Philippine courts will assume the foreign law is the same as Philippine laws. General rule: Philippine courts are not authorized to take judicial notice of foreign laws, except, number 1, where there are exception circumstances when the foreign laws are already within the actual knowledge of the courts, or generally known or actually ruled upon in a prior case. Number 2, where the courts are familiar with the specific foreign laws, example, Spanish civil law. Number 3, where the adverse party did not dispute the application of foreign law. Number 4, where the tribunal is a quasi-judicial body which is not bound by strict rules of technicality. Citizenship and domicile. Nationality principle. The law of country where a person is a national governs his family rights and duties, status, condition, and legal capacity, as opposed to domiciliary principle, which applies the law of the country of domicile. Citizenship, status of being a citizen of a state who owes allegiance to the state and is entitled to its protection and to the enjoyment of civil and political rights therein, who are citizens, natural persons, those who are citizens of the Philippines at the time of adoption of the 1987 Constitution, those whose fathers or mothers are citizens of the Philippines, those born before January 17, 1973, of Filipino mothers who elect Philippine citizenship upon reaching the age of majority, those who are naturalized in accordance with the law. Number 2, juridical persons 60% Filipino owned. Number 2, modes of acquiring Philippine citizenship by blood or jus sanguinis, natural born citizens, or by naturalization, naturalized citizens. Jus sanguinis, Valles versus Comelec. Facts: Rosalind Ibasco Lopez was born on May 16, 1934, in Australia to a Filipino father and an Australian mother. In 1949, at the age of 15, she left Australia and came to settle in the Philippines, where she later married a Filipino and has since then participated in the electoral process not only as a voter but as a candidate as well. In the May 1998 elections, she ran for governor, but Valles filed a petition for her disqualification as candidate on the ground that she is an Australian. Issue: whether or not Rosalind is an Australian or a Filipino. Held: the Philippine law on citizenship adheres to the principle of jus sanguinis, therefore a child follows the nationality or citizenship of the parents, regardless of the place of his or her birth, as opposed to the doctrine of jus soli, which determines nationality or citizenship on the basis of place of birth. The herein private respondent, Rosalind Ibasco Lopez, is a Filipino citizen, having been born to a Filipino father. The fact of her being born in Australia is not tantamount to her losing her Philippine citizenship. If Australia follows the principle of jus soli, then at most private respondent can also claim Australian citizenship, resulting to her possession of dual citizenship. The fact that she holds an Australian passport and alien registration certificate is an assertion of her Australian citizenship, but not a renunciation of Philippine citizenship. Moreover, by filing her certificate of candidacy, she has effectively renounced her Australian citizenship. Election of citizenship procedure: express such intention in a statement to be signed and sworn by the party concerned before any officer authorized to administer oath. File the sworn statement, together with oath of allegiance to the Philippine Constitution, with the nearest civil registry. The election must be made within reasonable time, 3 years from reaching the age of majority. Dual citizenship: the status of a person who is a citizen of 2 or more countries at the same time, who may possess dual citizenship: those born of Filipino fathers and or mothers in a foreign country, which follows the principle of jus soli; those born in the Philippines of Filipino mothers and alien fathers, if by the laws of their father's country such children are citizens of that country; those who marry aliens, if by the laws of the latter's country the former are considered citizens, unless by their act or omission they are deemed to have renounced Philippine citizenship; those who retain or reacquire their Philippine citizenship under RA 9225 after having been naturalized in a foreign country. General rule: dual citizenship is retained. Exception: the person expressly renounces his other citizenship by filing a certificate of candidacy or by accepting an appointive position in government. Dual citizenship as ground for disqualification from office: filing of certificate of candidacy as effective renunciation of American citizenship. Mercado versus Manzano. Facts: Mercado and Manzano are both running for vice mayor of Makati City. Manzano got the highest number of votes, but his proclamation was suspended in view of a pending petition for his disqualification on the ground that he is an American citizen. Manzano is both born in 1955 of Filipino father and mother. However, since he is born in the U.S., he is considered an American under the Jus Soli Doctrine. Upon his return to the Philippines, he is registered as a foreigner with the Bureau of Immigration. Issue whether or not Manzano is disqualified on ground that he is an alien. Held, Manzano is a dual citizen, but his being such does not disqualify him from running for public office. Under the LGC, what is prohibited is dual allegiance and not dual citizenship. The two terms are different. Dual allegiance refers to a suitable situation in which a person simultaneously owes, for some positive act, loyalty to two or more states. Dual citizenship arises when, as a result of the concurrent application of different laws of two or more states, a person is simultaneously considered a national by the said state. Moreover, Manzano is considered to have renounced his American citizenship by filing his certificate of candidacy. Loss and reacquisition of Philippine citizenship. How Philippine citizenship is lost by naturalization in a foreign country prior to RA 9225. Number 2, by express renunciation of citizenship. And number 3, by subscribing to an oath of allegiance to support the Constitution or laws of a foreign country. Number 4, by accepting commission in the military, naval, air service of a foreign country. Number 5, by cancellation of certificate of naturalization. And number 6, by having been declared by competent authority a deserter of the Philippine Armed Forces in time of war, unless subsequently a plenary pardon or amnesty has been granted. Express renunciation of Philippine citizenship. U versus Defensor Santiago, GRL 83882. Facts. Petitioner is a Portuguese national who acquired Philippine citizenship by naturalization. However, despite his naturalization, he still applied for and was issued a Portuguese passport and declared his nationality as Portuguese in commercial documents he signed. Issue whether petitioner's act constitute renunciation of his Philippine citizenship. Held. Express renunciation means a renunciation that is made known distinctly and explicitly and not left to inference or implication. Petitioner with full knowledge and legal capacity after having renounced his Portuguese citizenship upon naturalization as a Philippine citizen, resumed or reacquired his prior status as a Portuguese citizen, applied for a renewal of his Portuguese passport. To the mind of the court, the foregoing acts considered together constitute an express renunciation of petitioner's Philippine citizenship acquired through naturalization. How Philippine citizenship is reacquired. 1. By direct act of Congress. 2. By naturalization. Take the oath of allegiance to the Republic. Number 3. By administrative repatriation. Take the oath of allegiance to the Republic and register the same in the local civil registry of the place where person resides or last resided. Original citizenship is recovered. Repatriation. Pengson III versus HRET GR 142840. Facts. Respondent Cruz was a natural-born Filipino who lost his Philippine citizenship when he enlisted in the U.S. Marine Corps and subsequently became a naturalized American. When he returned to the Philippines, he reacquired his Philippine citizenship through repatriation. Later, he ran for a seat in Congress and won, but Pengson III questioned his election into office on the ground that he was not a natural-born Filipino. Issue whether or not Cruz's repatriation resulted in his reacquisition of his status as a natural-born Filipino. Held. Repatriation results in the recovery of the original nationality. This means that a naturalized Filipino who lost his citizenship will be restored to his prior status as a naturalized Filipino citizen. On the other hand, if he was originally a natural-born citizen before he lost his Philippine citizenship, he will be restored to his former status as a natural-born Filipino. In Respondent Cruz's case, he lost his Filipino citizenship when he rendered service in the armed forces of the United States. However, he subsequently reacquired Philippine citizenship under RA 2630. Having thus taken the required oath of allegiance to the Republic and having registered the same in the Civil Registry of Maganterem, Pangasinan in accordance with the aforecited provision, Respondent Cruz is deemed to have recovered his original status as a natural-born citizen, a status which he acquired at birth as the son of a Filipino father. It bears stressing that the act of repatriation allows him to recover or return to his original status before he lost his Philippine citizenship. Citizenship by naturalization. 3 modes of naturalization. Administrative naturalization, available only to aliens born and residing in the Philippines. Number 2, judicial naturalization. 3, legislative naturalization. Qualifications for administrative naturalization. RA 9139. Must be born in the Philippines and residing therein since birth. 2. Must be less than 18 years old at the time of the filing of the petition. 3. Must be of good moral character and believes in the underlying principle of the Constitution and must have conducted himself in a reapproachable manner during the entire period of residence. 4. Must have received his primary and secondary education in any public school or private educational institution. 6. Must have a known trade, business, professional, or lawful occupation. 6. Must be able to read, write, and speak Filipino or any of the dialects of the Philippines. 7. Must have mingled with the Filipinos and evince a sincere desire to learn and embrace the customs, traditions, and ideals of the Filipino people. Grounds for cancellation. 1. Made any false statement or misrepresentation, or committed any violation of law, rules, or regulation in connection with the petition for naturalization. 2. Within 5 years next following the grant of Philippine citizenship, established permanent residence in a foreign country, covers the wife and children as well. 3. Allowed himself to be used as a dummy in violation of any constitutional or legal provision requiring Philippine citizenship, covers the wife and children. 4. Committed any act inimical to national security, covers the wife and children. G. The Lex Domicile rule. Lex Domicile principle. The law of the place of the domicile governs. Domicile. Place of habitual residence, a place to which whenever absent for business or for pleasure, one intends to return, and depends on facts and circumstances in the sense that they disclose intent. Element. Physical presence. Number 2. Animus manendi, intention of returning there permanently. The law of the form governs the standard of domicile. If domicile is put in issue, the court will apply its own laws to determine the controversy. Kinds of domicile. 1. Domicile of origin or by birth. Domicile of choice. Domicile of operation of law. Rules regarding domicile. A man has a domicile somewhere. A domicile once established remains until a new one is acquired. A man can have but only one domicile at a time. How a new domicile is acquired. Actual removal or actual change of domicile. 2. Bona fide intention of abandoning the former place of residence and establishing a new one. 3. Acts which corresponds with such purpose. All the foregoing elements must be proved in order to rebut the presumption of continuity of domicile. Domiciling residence. Residence, the actual relationship of an individual to a certain place, physical presence of a person in a given area, community, or country. Residence is used to indicate a place of abode, whether permanent or temporary. Domicile denotes a fixed permanent residence to which, when absent, one has the intention of returning. A man may have a residence in one place and a domicile in another. Residence is not a domicile, but domicile is residence coupled with the intention to remain for an unlimited time. A man can have but one domicile for the same purpose at any time, but he may have numerous places of residence. His place of residence is generally his place of domicile, but it is not by any means necessarily so, since no length of residence without intention of remaining will constitute domicile. Romualdus Marcus versus Comelec. Domicile for election purposes under Romualdus Marcus versus Comelec. Facts. Petitioner Imelda Marcus filed for her certificate of candidacy for the position of representative of the 1st District of Leyte. She stated in the COC that she is a resident of the place for 7 months. Private respondent Montejo subsequently filed a petition for cancellation and disqualification on the ground that Imelda failed to meet the constitutional requirement of 1 year residency. Comelec granted the petition for disqualification, holding that Imelda is deemed to have abandoned Tacloban as her place of domicile when she lived and even voted in Ilocos and Manila. Issue whether or not Imelda is deemed to have abandoned her domicile of origin. Held. An individual does not lose his domicile even if he has lived and maintained residence in different places. Residence imply a factual relationship to a given place for various purposes. The absence from legal residence or domicile to pursue a profession, to study, or to do other things of a temporary or semi-permanent nature does not constitute loss of residence. Thus, the assertion that she could not have been a resident of Tacloban City since childhood up to the time she filed her certificate of candidacy because she became a resident of many places files in the face of settled jurisprudence in which this court carefully made distinction between actual residence and domicile for election purposes. Nationality and domicile of corporations. The nationality of a private corporation is determined by the character or citizenship of its controlling stockholders. The domicile of a domestic corporation is its principal place of business contained in the AOI. For foreign corporations, their domicile is the country under whose laws they are incorporated. Two tests to determine Filipino corporation. 1. Grandfather rule governs the district application of the ownership of a corporation, generally 60% Filipino-owned. Control test. A corporation that is at least 60% Filipino-owned is considered a Filipino, or for purposes of determining the Filipino ownership of a corporation whose nationality is put in issue. Corporation domiciled in one state but doing business in another is a resident of the latter. Northwest Orient Airlines versus CA, GR 112573. Facts. Northwest, a U.S. corporation, and Sharp, a Filipino corporation, but with a branch in Japan, entered into an agreement whereby the former authorized the latter to sell its air transportation tickets. Sharp, however, was unable to remit the proceeds of the ticket sales, prompting Northwest to sue for collection in Japan. Summons was served on Sharp's branch office in Japan, but because the manager authorized to receive summons was said to be in Manila, the same was also served on Sharp's Manila head office through diplomatic channels. Sharp nevertheless failed to appear during the hearing, and judgment was rendered. Northwest now filed a case before the Philippine court to enforce the foreign judgment. Issue whether or not the Japanese court acquired jurisdiction over the person of Sharp. Held. The domicile of a corporation belongs to the state where it was incorporated. In a strict technical sense, such domicile as a corporation may have is single in its essence, and a corporation can only have one domicile, which is the state of its creation. Nonetheless, a corporation formed in one state may, for certain purposes, be regarded as a resident in another state in which it has office and transacts business. Inasmuch as Sharp was admitted doing business in Japan through its duly registered branches at the time the collection suit against it was filed, then in the light of the processual presumption, Sharp may be deemed a resident of Japan, and as such was amenable to the jurisdiction of the courts therein, and may be deemed to have asserted to the said court's lawful methods of process. Foreign corporation doing business in the Philippines is a resident. State Investment House versus Citibank, GR 7992627. Facts. Consolidated Mines, or CMI, obtain loans from Citibank, Bank of America, and HSBC, all foreign corporations, but with branches in the Philippines. Meanwhile, State Investment House, or SIHI, and State Financing Center, SFCI, also creditors of CMI, filed collection suits against the latter with writs of preliminary attachment. Subsequently, the three banks jointly filed with the court a petition of involuntary insolvency of CMI. SHI and SFCI opposed the petition on the ground that the petitioners are not resident creditors in contemplation of the insolvency law. Issue whether or not a foreign corporation with a branch in the Philippines and doing business therein can be considered a resident. Held, foreign corporations duly licensed to do business in the Philippines are considered residents of the Philippines, as the word is understood in Section 20 of the Insolvency Law, authorizing at least 3 resident creditors of the Philippines to file petition to declare a corporation insolvent. The tax code declares that the term resident foreign corporation applies to foreign corporation engaged in trade or business within the Philippines, as distinguished from a non-resident foreign corporation which is not engaged in trade or business with the Philippines. The offshore banking law states that branches, subsidiaries, affiliates, extension offices, or any other units of corporation or juridical person organized under the laws of any foreign country operating in the Philippines shall be considered residents of the Philippines. The General Banking Act places branches and agencies in the Philippines of foreign banks in the category as commercial banks, rural banks, stock savings, and loan association, making no distinction between the former and the latter in so far as the terms banking institution and banks are used in said act. Contract. Lex loci contractus. General rule. The law of the place where the contract is made or entered into governs with respect to its nature and validity, obligation, and interpretation. Exception. When parties agree as to the choice of law. Number 2. Lex residendi in case of contracts affecting land or title thereto. Lex loci contractus governs only with respect to the forms and solemnities of the contract. Extrinsic validity. Intrinsic validity is generally governed by the national law of the parties. Choice of law by the parties and exemptions. General rule. The parties to a contract may select the law by which it is to be governed. In adopting a foreign law as the choice of law, the foreign law shall be deemed to be incorporated into the contract as the set of terms. Exception. Where the foreign law chosen is contrary to preemptory provision dealing with matters impressed with public interest. Number 2. Where the relationship of the contracting parties affects public interest in the country of one of the parties, where the substantial contracts arising therefrom point to the law of another country as the applicable law. Contract stipulation, Philippine law or law of registry, whichever is higher. North Management versus NSB, GR 54204. Facts. The deceased husband of complainant herein was employed as a second engineer by respondent and served as such in a vessel MT Cherry Earl. While at sea, he suffered apoplectic stroke and died 4 days later. Complainant widow thus filed a claim for that benefit and contended that in determining amount of the claim, the law of Singapore, where the vessel is registered, should be considered. For its part, the respondent argued that Philippine laws should govern, considering that the law of Singapore was never presented and the NSB cannot take judicial notice of foreign laws. Issue. Whether or not the law of Singapore ought to be applied in a case. Held. Supreme Court held in the affirmative. On the issue that Singapore law was not presented before the NSB, Supreme Court held that NSB, being an administrative and quasi-judicial body, is not bound strictly by technical rules. It has always been the policy of this board that in cases of valid claims for benefit on account of injury or death, while in the course of employment, the law of the country in which the vessel is registered shall be considered. Moreover, the employment agreement stipulated that compensation shall be paid under Philippine law or the law of registry of the vessel, whichever is higher. Thus, the amount under Singapore law being higher, the same should apply in accordance with the stipulation. Contract is law of the parties. Bagong Pilipinas Overseas Corp. versus NLRC GR 66006. Facts. Pancho was hired by Bagong Pilipinas Overseas Corp. as an oiler on board the M/V Olivine, a vessel registered in Hong Kong. While the vessel was docked at Gothenburg, Sweden, he suffered a cerebral stroke and was rushed to the hospital. Later, he was repatriated to the Philippines where he died later on. His widow filed for compensation benefits with the NSB, while Board awarded her the disability compensation benefits under the employment contract. NLRC, however, modified the decision and instead applied the law of Hong Kong, awarding a higher amount of benefits to the widow. Issue: whether or not the Hong Kong law should be applied. Held: Supreme Court held that the employment contract should be applied, not Hong Kong law. The case of North Management cannot be a precedent because it was expressly stipulated in the employment contract in that case that the workman compensation payable to the employees should be in accordance with the Philippine law or the workmen's insurance law of the country where the vessel is registered, whichever is higher. Such stipulation is not found in the employment contract between Pancho and Bagong Filipinas Overseas Corp. Exemption when contrary to public policy. Pakistan International Airlines versus OPLE G 61594. Pakistan International, a foreign corporation licensed to do business in the Philippines, executed 2 contracts of employment with private respondents for their services as flight stewardess. The contract had a term of 3 years, but also with the stipulation that, notwithstanding any provision to the contrary, the employer reserved the right to pre-terminate it at any time. Before the expiration of the 3-year term, Pakistan International sent notices of dismissal to private respondents, prompting them to file this case for illegal dismissal and recovery of wages and other benefits. Issue: whether or not the stipulation in the contract as to the right of the employee to terminate employees at any time should be respected. Held: Supreme Court held in the negative. A contract freely entered into should be respected, since a contract is the law between the parties. The principle of party autonomy in contracts is not, however, an absolute principle. The rule in Article 1306 NCC is that the contracting parties may establish such stipulation as they may deem convenient, provided they are not contrary to law, morals, good customs, public order, public policy. Thus, counterbalancing the principle of autonomy of contracting parties is the equally general rule that provisions of applicable law, especially provisions relating to matters affecting with public policy, are deemed written into the contract. Put a little differently, the governing principle is that parties may not contract away applicable provisions of the law, especially preemptory provisions dealing with matters heavily impressed with public interest. The law relating to labor and employment is clearly such an area, and the parties are not at liberty to insulate themselves and their relationships from the impact of labor laws and regulations by simply contracting with each other. No agreement and choice of law. If there is no express contract, the courts of the forum will apply any of the conflicts of laws, rules, such as lex locis celebrationis, like Bagong Filipinas Overseas, or state of the most significant relationship theory. In cases involving claims of Filipino workers on account of injury or death during employment or in the course of services in a vessel owned by the foreign employer, the law of registry of the vessel, if favorable to the worker, is applied. No agreement or treaty. The plaintiff makes the choice of the forum or the court where the action or complaint is filed. Thus, in Saudi Arabia Airlines Infra, there being no choice of law clause in the employment contract, the plaintiff chose to file her case before the courts of her home country, and the Philippine court applied the state of the most significant relationship theory to resolve the case in her favor. Lex loci contractus, or place of performance. The law of the country where the contract is to be performed generally governs the liability for breach of contract by the obliger to perform his part of the obligation. Place of contracting versus place of performance. 888 Integrated Services versus NLRC. Osfax Osdana, a Filipino citizen, was recruited by 888 for employment with the latter's principal, Gulf Catering Company, GCC, a firm based in the Kingdom of Saudi Arabia. The employment contract, originally as food server but later changed to waitress, was executed in the Philippines but was to be performed in Riyadh. Once in Riyadh, however, Ostana was made to perform strenuous tasks, washing dishes, janitorial work, which were not included in her designation as a waitress. In time, she developed carpal tunnel syndrome, for which she had to undergo surgery and weeks of hospital confinement. But when she returned to work, GCC informed her of her dismissal, allegedly on the ground of illness. Issue: whether or not Ostano was illegally dismissed from work. Held: there was illegal dismissal. GCC argued that the requirement of medical certificate from public health authority was physically impossible to comply with since Ostana was employed in Saudi Arabia and not in the Philippines, so there was no way for them to get the alluded medical certificate from the Philippine Public Health Authority. But Supreme Court held that the rules simply prescribed a certification by a competent public health authority and not a Philippine health authority. Also, the argument that Saudi Arabia laws should apply in is not obtaining. Established is the rule that lex loci contractus, the law of the place where the contract is made, governs in this jurisdiction. There is no question that the contract of employment in this case was perfected here in the Philippines. Therefore, the Labor Code, its implementing rules and regulations, and other laws affecting labor apply in this case. Furthermore, settled in the rule that the courts of the forum will not enforce any foreign claim obnoxious to forum's public policy.